Okay, thank you very much for the invitation to speak about some of my research here at Google. I'm going to talk about patent law and innovation and a number of issues that have arisen in my research that combine the two and disentangle the two and explore the connection between the two, which might seem obvious to people in the audience to begin with, and it seemed obvious to me when I started the research, but I think there's some interesting complications between patents and innovation. I'm a professor at the University of Kansas School of Law. My background is as a biologist. I have a Ph.D. from Harvard in genetics, and then I sold my soul and became a lawyer, and a patent lawyer even, and then gradually migrated back into academia. So the title of my talk is The Patent Game, Experimenting in the Cathedral of Law. And I hope that in a little bit you'll see why I chose that title, despite the fact the title is sort of a quizzical title. And by the way, the cathedral in question is the cathedral at Rouen that Monet spent about 6 months painting in a variety of different lighting conditions, atmospheric conditions, weather conditions, and came up with a variety of views of the cathedral. And I'm going to try and link the view of a single object from multiple perspectives to my research in patents and innovation. So what I'm going to talk about today is a collaboration with Professor Bill Tomlinson, who is at the University of California, Irvine. He runs the social code group there, and he's by far the smarter of the two of us. I came up with an idea about trying to test empirical questions of the patent system, and he made it possible. And so any good stuff that comes out of this talk is certainly Bill's, and any mistakes are certainly mine. I also want to acknowledge two other folks that helped very much. Bryant Davies, who is a graduate student at UC Irvine, he helped to code the first version of what came to be known as the patent game. And then Nitin Shantharam spent much of this summer working on a recode of the system that I think improved it in a number of ways. This project has become known to Bill and me as Patents and Innovation, or the Patents and Innovation Project. And it's a project that we've been doing for 3 years, and it's something that we expect to be doing for a number of additional years. We are very interested in something that seems banal and seems obvious to some people at least, which is the connection between patents and innovation, or the spurring of innovation. And the more that we've explored this topic, the more that we've realized the subject is complicated, convoluted, and quite non-obvious, to borrow a clumsy term from patent law. We've used an experimental system which we originally called Patent Sim or Sim Patent, but it didn't stick. Like a lot of original titles, it didn't stick. Everybody, including the user, started calling it the patent game. So now we've given in to democracy and we call it the patent game. But it's a simulation of the patent system using computers that plays like a game, and I'll speak more about that in a few minutes. We've tested a number of hypotheses so far using this experimental system, and the two hypotheses that I want to explore with you today are, one, that patents spur innovation. It's a common claim. It's an historic claim. It's a claim that most people that make it never question. But we thought we would actually look into this claim and try and probe it in a way that hadn't been done before. And more recently, we have looked into a variation of this question, and that question is whether property rights in a patent system outperform liability rights in a patent system. And without belaboring that point, and I'll explain it in more detail later, property rights in a patent system would be receiving an injunction if there was an instance of infringement, an injunction forbidding future infringement. That's a property rule or a property right, versus a liability right or a liability rule, which would be if someone infringes a patent, they might owe damages, but there's no comment as to future infringement. Infringement might go on as long as the price is paid for the infringement that's done. They're very different kinds of rules in the law, and we've recently had an opportunity to do some empirical testing of how patent systems perform under these different legal regimes, property rules versus liability rules. In both cases, at least we were surprised. It may be that folks here in particular will not be surprised at what we found, but it's spurred us on to explore additional questions and additional permutations of our research, because we think that trying to find a linkage and trying to establish a linkage between patents and other intellectual property rights and technological innovation, which is something that probably has huge social utility to society, innovation at least, is an important question to ask and an important finding to try to establish. I'm going to present the empirical results that we think shed a little bit of light, at least within our limited system, on these hypotheses. And then I'm going to talk a little bit about future research directions that we intend to go in. This, by the way, is James Watt's steam engine, or one of the various steam engines that he, along with a variety of other people, invented in a burst of technological creativity in England and particularly Scotland a couple hundred years ago. So the United States Constitution happens to consider patents so important that they put them right into the Constitution. Now, most interests in this country are not in the Constitution, and so it becomes harder to enforce your legal rights if you don't have a constitutional peg. But patents are right in there, so are copyrights, in fact. And the language that the Founding Fathers put into the Constitution go as follows. The Congress shall have power to promote the progress of useful arts by securing for limited times to inventors the exclusive right to their discoveries. Now, I've removed the language for copyright, in part because it was extraneous to this study, and also in part because 200 years ago, the language was a reverse of what you might expect, because useful arts sounds like something you might copyright, but 200 years ago, useful arts was actually technological innovation. And science 200 years ago, which refers to copyright, was actually writings 200 years ago. And I think in the minds of most people, these have reversed in the ensuing years. So we have a very strong authorizing clause in the Constitution that say we can have a patent system. Now, over the years, Congress has elaborated this right by coming up with various versions of the patent law. The most recent large innovation in patent law was 1952. That's the version of the Patent Act that we currently live with certain modifications that have occurred since then. Now, there's a traditional claim that is often made that without the prospect of patent protection, inefficiently few innovations would result. And I've put, as an illustration of this, a tragedy of the commons involving goats that have overgrazed a piece of land. Now, this is something that I think has passed into the culture as almost received wisdom, that without management, a common resource will become depleted. And certainly there is evidence that for certain resources, this phenomenon does occur. But this is a claim that has been extended beyond the physical world to the world of intellectual property. And many have claimed, and many have claimed with some reason, that if one is not able to protect one's new idea, other people might exploit that idea and expropriate the idea, thus create a negative incentive for anyone in the future to come up with an idea and share it with others, because without protection, they won't be able to benefit from it any more than their nearest neighbor who grabs the idea, doesn't have to come up with it in the first place, but is able to do the idea, practice it, carry it out, and maybe at a lower cost than the originator of the idea. Now, this project actually originated for me in the search for a footnote. I was writing a paper, and I wanted to drop a footnote in the paper that stood for the, at the time, quite obvious statement that patents promote technological innovation. And so I sent this project down to my research assistants, and they kept emailing back saying they couldn't find anything that would make an appropriate footnote. Now, I put this down to rookie mistakes. I thought they're just not looking in the right places. So eventually I got frustrated and looked for it myself. All I was looking for was some authoritative source in the literature that said that technological innovation is spurred by patent protection. I couldn't find it either, and I thought that was the strangest thing that had happened to me in academia up to that point. But what I did find, among other things, was a study done by the National Academies, which was published in 2003, which was a definitive and fairly exhaustive look at the literature going back hundreds of years, trying to find connections between patent protection and innovation. And I won't share the entire report, it's quite voluminous with you, but I will share a couple of statements that I thought really were attention-grabbing. One is, the literature on the impact of patents on innovation must be considered emergent. Now, that's obviously a nice euphemism. That's, that's in there not to hurt feelings. Emergent sounds kind of nice, but what it really means is people haven't done this yet. They haven't made the connection, at least according to the folks that combed through the literature. So emergent sounded to me like a little bit of a challenge. I thought, maybe I can help to contribute to this debate. And in fact, at the time, having recently been a patent attorney, both in a firm and inside a company, I thought, well, obviously patents do spur technological innovation. I know it. I mean, I practiced it. People paid me to do it. So I'll try and come up with some way that I can supply a footnote for people in the future. So this is essentially the origin of our experimental approach. I looked into other methods. Many of them were beyond my abilities, involving tremendous economic analysis, and I'm not an economist. But with my colleague, Bill Tomlinson, I thought we could maybe take an experimental approach. And I was fairly confident that I knew what the answer would be. Now, the report also says the effect of patent policy has many dimensions, some fundamental to understanding the determinants of innovation generally, and these continue to challenge scholars both theoretically and empirically. So again, a little bit euphemistic. It's essentially asking people to find some evidence because they couldn't. So we decided to take up the challenge. We decided to use an approach which is the simulation game. There are a number of advantages of simulation games, a number of reasons why simulation games are increasingly used to study phenomena in the real world. This, by the way, on the right-hand side is a climate model, a climate simulation, not a game, but a simulation. So game simulations are often considered to be useful within the field because, first of all, they enable rigorous manipulation of experimental conditions. You can control the experimental conditions by controlling the code that the computer users interact with. It also integrates human interaction with real-time computational processes, and it allows for very precise data collection. Some advantages of interactive simulations are that they're dynamic. They use human behavior to model human behavior, which is actually a very powerful aspect of interactive simulations. In a lot of cases, computers are used to model human behavior, and it's a very powerful approach. But what this approach does is it tries to harness the complexity of humans, feed it through the bottleneck of code, and then reveal additional aspects of human behavior based on how humans interact with the system. Obviously, it's fraught with complexities and potential for error, but it's seen in the field of simulations as an advantageous approach to try and harness humans to study humans. It generates a tremendous amount of data. We record every keystroke in our database, and we've barely touched the surface of the data that we've gathered so far. You can use existing data to set parameters. So you can look into the real world and try and estimate what your system should try and simulate, and then set the parameters to reflect that. And then you can change those parameters, and you can run human subjects on different sets of parameters. You can compare results based on alternative sets of parameters, and you can directly test alternative hypotheses, which is what we wanted to do. First of all, we wanted to test the hypothesis that patents spur technological innovation, at least in our system. Interactive games, a kind of interactive simulation, also have some advantages that also come with challenges. So one of the challenges in coming up with a good interactive game, at least as seen from within the field, is you have to make the game compelling and fun, And the way that that's measured, however unscientific, is if it is compelling and fun, then the users might forget that they're actually playing a game. Or they might mostly concentrate on what they're supposed to be doing in the game rather than thinking the whole time, oh, I'm just playing a simulation game. So one of the tests that we had for the success of our system was trying to figure out whether users found it compelling and found it fun. And fortunately, those two criteria, I think, were satisfied. Folks seemed to really enjoy playing our game, and they seemed to get engrossed in it. We had lots of fist pumping, lots of in-your-face yelling at the ends of games, too much excitement and talking in general, so we were constantly trying to tamp down the noise and the movement within the test rooms. And I even received phone calls sometimes in the evening from players that were getting together with a bunch of friends that night, and they thought that it would be fun to play the game. Now, obviously, that would have interfered with the integrity of our data gathering, so I generally turned those requests down. But the strong impression that we got was that people liked playing the game and that they really got engrossed in it. They really wanted to win it, and to a certain degree, they stopped thinking of it as an interaction and really became a part of it. One of the nice things about interactive games is that you don't really need to explain to people what the purpose is. In fact, we didn't explain. We didn't say, for example, what we would like you to do is prove that patents spur technological innovation. Go ahead. Instead, we simply explained how the system worked, and we defined a goal for the players. The goal was often to make more money than any other player. We had a variety of ways of encouraging that, rather than tell them what the purpose of the experiment was. So having explained the rules and having allowed the subjects to become comfortable with the system, we could set them loose, and we might know what the results could be, either to falsify or to satisfy the hypothesis. But the players didn't need to know that. They simply needed to know how to invent things, for example, how to license, how to assign, how to litigate, etc. And I'll show you in a moment how that works. It's easy to generate sufficient sample sizes with this approach, and it's, in the law at least, an untapped data source, which was very attractive to us. This is not something that the law does in general. It's something that social sciences don't do that much, although economics has used this approach for years, and I think it's becoming an increasingly favored approach in economics. So a couple of goals of the patent game. We wanted to successfully simulate patent systems. We wanted to collect and analyze all of the data generated by users. We wanted to test specific hypotheses that might get to the following issues. How do patents spur innovation, if they do? Do outcomes vary with specific parameters, and if so, what would those parameters be? And is there an optimal system for innovation? So that's a project that's more for the future, I think, although I think we've shed a little bit of light on what sets of parameters, at least within our system, perform better than other sets of parameters. The database structure allows the implementation of almost any patent system feature. The patent system itself is fairly technical, and this becomes an advantage when you're trying to simulate it, because it's relatively straightforward in many cases to choose an implementation in code that would seem to reflect the essence of that aspect of patent law. We used Ruby on Rails, and we aimed for ease of function, or ease of use for the users. So drag and drop inventing. Inventing is relatively easy. You do it with a mouse. The difficult part is coming up with a great invention, but you don't need machine tools in a laboratory. You just need a mouse and a little bit of coordination. We tried to use pull-down menus. We tried to update events so that the user didn't have to do that themselves. And we tried to use auto-refreshing. All of these are fairly trivial features, but we tried to make sure that the system itself was as non-distracting as possible so that users could concentrate on playing the game and attempting to win within the parameters we had set. Now, the goal for the user was to win the game, and we've tried a variety of incentives to get people to really go for it. One possibility is a prize for every single trial. So every winner of a trial, every scorer of the most points or generator of the most income in a trial wins a prize. And we tried a variety of different prizes, from fine chocolates to money. We also provide an incentive for those that come second, third, fourth, and fifth in some of our trials by assigning a probability of winning based on the points that you score. So this was to solve a problem that could have arisen if one player was so far ahead of the other players it became futile to try because they'd never win. So instead, it still makes sense to score points and earn money because it raises the chances that you'll be the winner. The person with the most points doesn't necessarily win. He just has a higher probability of winning. So what do we actually implement in the patent game? And a lot of these are aspects of patent law which may put non-patent lawyers to sleep, might even put patent lawyers to sleep. But I'll go through them because I think it's important to see which elements we did try and implement. So for inventing, we used the proxy of elements. Now, these elements could be numbers, symbols, letters, and in most of our trials, we used letters. So A, B, C, D, E, and F were presented as potential building blocks of inventions, and inventors could take those letters and make combinations. For example, A, C, D, or A, E, F, or A, B, C, D, E, F. So the inventions could be long, they could be short. Those were the raw materials that were available for inventing. Now, combinations of elements were what became inventions in the game. We did not allow, for example, the patenting of basic building blocks. That may be a flaw of the current patent system, that it does allow the patenting of basic building blocks, at least in the mind of some critics. But you could not patent an A in our game. We considered the fact that A was pre-existing out there to reflect the fact that A was simply, an element of nature, phenomenon of nature. But AB, if you put it together, was potentially an invention, or ABC or ABCD. We took very careful track of prior art. So if someone had already made an ABC, you couldn't patent ABC in the future. And if somebody had made an ABC, similarly, you couldn't patent lesser included strings such as AB or BC. And so the computer kept track of prior art, and prior art was often announced at the top. If you tried to patent something which had already been made or used or patented, the computer would say, I'm afraid you can't patent that. There's already pre-existing prior art. We also had a distinction between making and patenting in our game. So you could make a combination of elements and make it, and then if you wanted, sell it on the market for whatever price the market would bear at the time. Or if you wanted, you could patent that combination. Now, we had different possible settings for making and patenting. In the US system, you can make something and still patent it if you do it within a year. In the rest of the world, if you make something and put it out there in the market, you can't patent it once it's been revealed to the public. It's an absolute novelty system versus the system we have here, which involves a grace period. We actually, in most of our experiments, used the absolute novelty rule. So once you made something or used something, you couldn't patent it. Nobody could patent it, not the user or any other player. We also included functionality allowing people to license or to sell inventions. So having invented, for example, ABC, if one wished, one could make ABC available for licensing to other players for a set price, and the owner of the patent would set that price. Similarly, if you didn't want to continue infringing someone else's patents, and they were making their patents available for license, you could sign up and buy a license, and henceforth, you could make that combination without being sued. We also had an infringement and enforcement system. So if one makes a combination which is patented by someone else, the owner of the patent has the opportunity to sue if they wish. And when they sue, they have the option of hiring a certain number of lawyers, and lawyers are expensive. And so if you hire a lot of lawyers, it costs you a lot of money. Now, in various trials we've done, we weighted legal effort sometimes greater or lesser extent. So for example, sometimes if you hire a bunch of lawyers, it really helps you to win. If you have 10 lawyers and someone else has 1 lawyer, chances are the person with 10 lawyers will win in some trials. In other trials, we minimize the effect of lawyers. Now, there's some evidence that having a large legal effort does help up to a certain point, and certainly some companies use teams of lawyers to intimidate other companies into giving up. And if you're a single inventor with no lawyer and you go up against a company that has professional patent litigators, your chances aren't great that you're going to win for procedural and substantive reasons. But this varied in different ones of our trials. But suffice it to say, you could vary your legal effort. Now, the defendant, having been sued, they also had the choice to hire a lot of lawyers or few lawyers. But again, there was a cost, and the cost was a non-trivial cost in most of the trials that we did. There were various things you could win if you successfully litigated. You might get an injunction, and the injunction would prevent future making or using of the patented combination which was at issue in the litigation. Or you might get damages. And we actually incorporated into our system not just single damages, not just the costs that you inflicted on the owner of the patent by infringing, but to reflect the patent system in the United States and some other countries, we included what's called treble damages. So you had a certain percentage chance of winning 1 times damages, a certain percentage chance of winning double damages, and a certain percentage chance of winning treble damages, triple damages. So for example, if the damages were $1,000 or $1 million, under treble damages, the judge would actually triple those up to 300 or 3 million. Oops, I think we've skipped forward here, sorry. We also have the possibility in our system of establishing a patent term. So patents could last for the whole game, or patents could last for 5 minutes, or for 10 minutes, or for 15 minutes. So this is something that we hope to explore in the future, the effect of expirations of patents. In the real world, in some industries, companies hang on the prospect of expiring patents, and the moment the patent expires, they start to use the patented technology with impunity because it's no longer under patent. We also incorporated a number of costs into the game. So for example, it costs money to patent. Those reflect prosecution costs that an inventor would pay to the Patent and Trademark Office and pay to patent attorneys who assist with the preparation and filing of patents. And also time. It takes time to come up with good inventions. And in our game, it sometimes pays off to take your time to invent quality inventions that are worth more rather than patenting willy-nilly anything that comes into your mind. The chances are that most inventions in our system and in the real world are not worth terribly much on the market. I already mentioned the costs of litigation. The costs of litigation can be substantial in the game, and it's up to the players to decide whether they want to spend a lot of money on lawyers, and obviously they sometimes take a chance that they'll lose as a consequence of saving money on lawyers. We also have the possibility of multiple users versus no users. We can set our system on autopilot, but the trials that I'll show you are based on multiple users who've used the system. So this is an example of what the interface generally looks like. And let me point out a couple of features. In the upper left-hand corner, it shows how much money each player has. And each player is assigned a different color. And so this updates automatically, and players in the trials that generated the data I'll show you, they knew what other players had in terms of money. So this might be akin to seeing documents from the SEC or estimates of market value, et cetera. Below the money box is the design box, and this is where one invents inventions. And so the A, B, C, D, and E are the raw materials, and you drag those down into the invention box, and you can change their orientation. You can only use, in the trials that we used for the data I'll show you, we only used one letter, so you can't do A, but you can do A, B, C, etc. So your inventions can be as small as two elements or as large as 5. Or we can also include 6, 7, 8. There's no limit to the number of elements that you can use. Then you have a choice. You can choose to make it, and if you make it, you will be told, if you make this, you can also sell it, and the market will give you X number of dollars for your invention. So you can make money that way and augment your money in the upper left-hand corner. Or if you want, you can choose to patent it. And when you choose to patent, it will tell you what the cost of patenting is, and you go through that process, and you come up with a patent. Now, in the middle column, it shows your patents. So you have a convenient place to keep track of your intellectual property. So for example, in this game, the player in red has the patent AC, and its value at the current time on the market, if you were to make it and sell it, is $2. Not a terribly good invention. They also have the possibility of clicking the hot link for license and sell and making that patent available for license to other players for whatever amount of money they want. If they sell it, they actually lose the patent. This is true to the real world. If you assign your patents, then the party that buys it now owns the patent, and they could actually apply it back against you if you infringed the patent you used to own. You also have a place where you keep track of your licenses. So if you acquire some licenses, you'll know which licenses you have and how long the licenses last. And then other patents. In some versions of the game, we allow everybody to see the patents that other people have, which isn't terribly unreflective of the real world, because if you want to see what patents other people have, you can search the PTO database, or actually Google Patents is probably a more effective way of looking that up these days. And then events are tracked on the right-hand side in certain versions of the game. And so, for example, Alice made BA up here. Carol patented CDA. Carol patented AE. Alice made DBA. Alice patented AC. And if an infringement event occurs, the player that owns the patent will be given a little hot link saying, your patent may have been infringed. Would you like to sue? And if you click that, it takes you into the litigation function. A number of strategies are available. And these are strategies that we've noticed employed by different players. One is play it safe. Some people really don't like to infringe. They don't like the feeling of having infringed, the feeling of being sued, so they play it safe. If they want to use someone's invention, they license it or they buy it. Other folks have no such compunction. They play fast and loose, they infringe, and in some cases it's not worth suing, especially if the patent isn't worth very much. And so sometimes they get away with it, and sometimes they get nailed in litigation. Sometimes people come up with more elaborate strategies. Sometimes they'll spend a lot of time patenting, coming up with good combinations, experimenting, patenting, and then at a certain stage in the game, they'll sort of come out and start to sue people or start to make things that are protected by their patents. Some people have elaborate licensing strategies. I've seen some players that try and find key pieces of, or key inventions that later became useful to a lot of other players, and they sit back and just harvest the licensing revenue. They make the patent available for license, and it can be a very successful strategy sometimes. Sometimes players just want to sell what they've discovered, and sometimes they charge large amounts of money for others to buy their inventions. And then there's the question of enforcement. Some people have very sophisticated enforcement strategies. Some people enforce against everyone all the time. So they're constantly enforcing, they're constantly in court. That might sound like some companies that you may know. Other folks are more selective, and they'll only sue when they desire, when they think that it's desirable, or when they think that their patent is especially valuable. Some players ignore all the rules and just go for it, no matter what the consequences are. And there's a whole bunch of mixed strategies that are also available. Yes?
Do people get to play the game more than once?
Sometimes they do, and sometimes they don't.
Does one play with certain settings seem to affect people's strategies for later plays?
That's a really good question. Honestly, I don't know the rigorous answer to that question. We have the data. You can imagine it's like swimming in an ocean. We have to choose what to look at. But that's something that we do plan to look at, because I've made notes on various trials where I suspect that something interesting is going on. And I've made notes on the particular trial and the particular player to look into the database later. But I'm afraid I can't comment in a rigorous way because I haven't really looked at it rigorously. But it's a great question. Yes, sir?
Did anybody try
Absolutely. Some do, and some do it with extreme glee. It's interesting. The emotions that come up in this game, I mean, it shouldn't be unpredictable. You're using humans to model human behavior. But the emotions that often come up are quite interesting. Some people take it quite personally when they're sued. Other people are very dispassionate about the whole thing. Some people get angry, and some people just stay cool, calm, and collected. A couple of observations that are qualitative observations. We don't have the data yet to back these up because we haven't had the chance to look through the database for it, but players do seem to enjoy playing. I've yet to find a player that seemed bored. Sometimes players appear to be frustrated if they're not winning, but players appear to enjoy the game, and we usually get oversubscribed when we look for human users. Players really enjoy winning. This seems to be a universal phenomenon of human behavior, at least with respect to our system. As I said, there's fist pumping, there's whooping, there's in-your-facing. Players really like that. And again, that's good for us because that's one of the aspects that simulation games are judged on. Are they fun and compelling? Players appear to want patents. I'm not sure exactly what explains it, but it's possible that the endowment effect might play into this. Having invented something, you may want to protect it because it's yours. Similar phenomenon to walking along the seashore, seeing a rock that before you pick it up doesn't really mean that much to you, but once you've picked it up, you really like that rock. It's not a whole lot different than other rocks, but it's your rock now, and you'd rather not part with it. Players invent selectively and strategically. Again, it's hard for me to assign any rigorous analysis to this, but it's clear to us that there's a lot of selectivity in what's patented, what's made, what's licensed, what's sold, and which litigations are pursued and which are ignored. And there appears to be strategic behavior. Some players, in fact, many players, appear to be planning into the future of the game, and sometimes it's successful, and I imagine sometimes it's not. Players often will license, and they'll often sell their inventions if the price is right. And one thing that is clear, players often litigate. This is another place where emotion seems to bubble up in the game. Players often will sue if infringement occurs. Players also appear to care about which legal rules pertain to a particular game. And I'll show you some data on this in a little while, but players seem to care about whether, for example, you can get an injunction for infringement versus getting damages for infringement. So the first hypothesis that I'll walk you through and show you some data. The first hypothesis is that the prospect of patent protection for inventions promotes the progress of useful arts. This is language straight out of the Constitution, more than will the commons. So more than will a system in which there's no patent protection available. Oh, and this is an argument that's often made in the computer industry, in the biotech industry, in all sorts of industries, that you really need to have patent protection in order for innovation to occur. So in the first set of trials that I'll show you, by the way, this is all approved. We didn't do this under the table or behind the warehouse. This is all institutional review board approved. And I have to say that the folks that approved it were quite bemused that we were even asking approval. The last gentleman that I talked to who approved the first trial said, "It doesn't look like you're injecting or putting people in electrodes, so I think it'll be okay." Maybe if he saw the emotions that bubble up, he might have second thoughts. But this is all above board, properly approved. And we tested in the first trial that I'll show you a pure patent system. So a system in which if you chose, and if you did it before it was used or made or put on the market, you could actually patent your new invention. We had another system which we called the patent open source system, where you could patent if you wanted, or you could affirmatively give away the intellectual property rights. You could sort of anti-patent your invention if you chose. And although it's not exactly opposite to copyright open source, we were trying to get at the possibility of giving away rights as opposed to taking rights and see what effect that might have. So in that case, you could either patent or you could anti-patent if you chose. And then we had a pure commons. We had a system where you couldn't establish any proprietary rights to your inventions. Anybody could use them if they wished, and there was no recourse in litigation.
Can I ask you a quick question on that point?
Sure.
Was it possible to keep your invention secret under the pure commons?
Not in the trials that I'll show you, and that's something that we'd like to test in the future. And there's a variety of ways built into our system that will allow secrecy to occur. What we'd like to do in the future is see how important secrecy would be, but we didn't want to test it at the same time as patents, because then we'd have two variables instead of one relatively controlled variable. So it's a great question, and I suspect that we'll see an effect. Having been a little bit surprised by the results we've gotten so far, I'm not exactly sure what the effect will be, but I'm really curious to look into it. So yeah, we have plans to look into secrecy, and I suspect it'll be important. Sample sizes in this, for example, we ran 8 trials for the patent system, 8 for the open source patent hybrid, and 8 trials for the commons. And each game was played with 5 players. The reason we chose 5 players is in most industries, there are about 5 companies that occupy more than 80% of the market. So rather than play with 10, which can get a little bit cumbersome and also costs a lot of money when you're paying human subjects, we settled on 5 because that would represent the vast majority of the market in most industries. The duration of these games were 30 minutes, and they were exactly timed. And we sort of used mutual controls in the sense that there was a commons, no patent protection, versus 2 systems of patent protection, the patent and the patent open source protection. So innovation. Unique inventions invented in 30 minutes, the average number, turned out to be lower in the trials that we ran, lower in both the pure patent system, the blue, and also the patent open source system, the green. And the pure commons system, the system without intellectual property protection, this outperformed both of them to a statistically significant degree at the 5% level. So this is the number of unique inventions made during trials. We also looked at what we called productivity. So productivity, the way that we measured it was not the number of unique inventions made, but the total number of things that were made during a trial, even if there were overlaps. So something might have been made 5 times. In the first graph, it would be counted once. In the second graph, it would be counted 5 times. So sort of proxy of economic activity. The advantage that the pure commons had was exaggerated in productivity compared to the innovation measure that we did. And we also measured social utility or wealth. So the total amount of dollars or money generated in the system during these trials. And the pure commons in this case ran away with the contest. And both the pure patent and the patent open source systems were relatively tamped down compared to the commons performance. So some data to put with the graphs, 76.8 versus 103.4 for the patent open source system versus the commons system. Productivity, it's about a doubling, about 322 versus 658. And then in terms of social utility or wealth, 41,000 for the commons and about 10,000 for the patent open source system. So what explains these rather odd results? And these results were, I have to say, so odd that I decided I better look into the data again, because I figured I must have done something wrong, because I knew that patents would outperform the other 2 systems, that patents would outperform the common system. So I thought, obviously, I've done something wrong. I looked through the data. I ran additional trials. They all lined up this way. So the commons, in our system at least, with the parameters we set, seem to outperform the other 2 patent systems. So why? What explains it? Well, one possibility is this is just a terrible simulation. In general, it's a bad simulation. It really doesn't simulate the patent system well. So you wouldn't expect good results or results reflective of reality. Another possibility is we set the wrong parameters. We could have set better parameters, and if we had, we might have gotten more realistic results. Another possibility is the players that we chose, just a bad cross-section. Now, we've actually tested this on a number of different sources of players now, and the results appear to be robust. But these are all possibilities, and we admit them. Another possibility is that despite the received wisdom, commons actually spur innovation better than do patents, at least in our system. Outside of our system, there's some evidence that this phenomenon may occur. So Heller and Eisenberg have talked about a tragedy of the anti-commons in genetics. Too many gene patents making it difficult for genetic research to occur after the patents have been granted. So geneticists and medical researchers paralyzed by the existence of intellectual property into not being able to further research because of the existence of what they call the anti-commons. Also, Eric von Hippel at MIT studied user and open innovation. His results show rather strikingly that a tremendous amount of innovation, empirically, occurs outside the patent system, and in fact occurs almost despite the patent system. Despite the possibility of liability, a lot of users innovate anyway, and in fact a lot of users both innovate and then go to companies and say, hey, your product's okay, I made it better. Could you please make it this way? Because I would buy 10 of them if you could make it this way. So there's a phenomenon that's not uncommon in the real world. Yochai Benkler, Larry Lessig, they've both written about theoretical reasons why this might be the case, at least under certain conditions. Besson and Moyer, an economist and a law professor, they have both looked into the empirics of innovation and patents, and they've concluded, although I'm obviously drawing too broad a brush of their book, they've concluded in their book that in most industries, the costs of the patent system outweigh the benefits of the patent system. Now, one industry where they find the costs not to be outweighed by the benefits is the pharmaceutical and biotech industry. But in software, which might be relevant especially at Google, the costs appear to vastly outweigh the benefits from a societal perspective, and probably from the perspective of individual companies. Not all companies, but many companies. I also want to mention particularly Elinor Ostrom. And Elinor Ostrom is why I have this slide here. This is a Swiss alpine meadow. And the tragedy of the commons, the image of the commons desolated because too many people are grazing too many cows in the commons and there's no property rights, no protection. This may actually be a rather English phenomenon. It certainly does happen in England, or did happen in England when people used to graze their cows in the commons. But the Swiss are different. The Swiss actually graze their cows in high alpine meadows, and I don't think the cows are distinctively different. I don't think the grass is distinctively different. But what's distinctively different is the cows don't seem to overgraze. And it's not really the cows. It's social norms appear to prevent the Swiss from overgrazing. And there's a number of examples around the world that Elinor Ostrom has cataloged. Another example is Maine lobster bays. So along the coast of Maine, there's all these distinct bays that are rich in lobster, and they don't seem to be overfished. And it turns out that there are very strong social controls. Social might be a euphemism for not overfishing lobster in those bays. Lobstermen, if they see other lobstermen overfishing, they sometimes pressure them. Maybe it's social ostracism, maybe it's worse than that, but in the end, in these bays in Maine, the lobster are not depleted, and there's strong forms of social control that seem to prevent the depletion. So there may be counterexamples to the tragedy of the commons that exist without legal control, that exist without patents or laws that are analogous to patents. So another hypothesis that we tested was an hypothesis that was inspired by a paper. It's one of the most widely cited papers in all of the legal literature. It's by Guido Calabresi and A. Douglas Melamed. It's called Property Rules, Liability Rules, and Inalienability. And you can see that I borrowed or adapted part of their title from my title. One view of the Cathedral. And in this seminal article, they proposed that different legal rules might actually have different effects. Now, they didn't talk about intellectual property at all. Mostly they were dealing with torts and property law. And one of the contexts that they talk a lot about is the ownership of real property, houses, land, and also accidents. What sort of rules you set for accidents like car accidents. And I want to say particular thanks to Fred McChesney, who suggested that we take a look at this paper and try and use our system to do an experimental test of their hypothesis that you might get different behaviors. This had not apparently been done before, and he thought that in the patent context, this might be amenable to some sort of experimental test. So we enthusiastically took his idea and adopted it and did the tests. This was also, I should thank the Searle Center and Henry Butler, who was the director of the Searle Center, and the various faculty at the Searle Center up at Northwestern. So what are property rules? What are liability rules? Well, a property rule, I'll just use the words of Melamed and Calabresi, it's an entitlement is protected by a property rule to the extent that someone who wishes to remove the entitlement from its holder must buy it from him in a voluntary transaction in which the value of the entitlement is agreed upon by the seller. So obviously the seller in this transaction has a tremendous amount of power. They have a veto power. They can say no. So this is like getting an injunction from a court. It's not exactly the same, but it's like getting an injunction where if you've got an injunction against further infringement, you can just say, no, I don't want you to further infringe. And if you do, you put yourself in danger of contempt of court and fairly strong censure. Now, what about a liability rule? A liability rule denies the holder of the asset the power to exclude others or indeed to keep the asset for himself. Rather, under the standard definition, he is helpless to resist the efforts of some other individual to take that thing upon payment of its fair value as objectively determined by some neutral party. So in this case, there is no veto. In this case, whatever entitlement you have can be taken by another, and the third party and the objective determination, this refers to courts. So you can take something from someone else, and their recourse is to go to court and get the fair market value for whatever was taken. Very different rules, property rules and liability rules. This is represented in our study by damages. If I infringe you, I owe you damages according to some estimation of what it was that I deprived you of by using your patent. Property rules, interestingly, are the rule in the law and in law and economics. There's very strong support, theoretically. Richard Epstein, who's at University of Chicago, he has on a number of occasions written about the dominance of property rules. And for example, he said, in any comprehensive legal structure, property rules should dominate liability rules, as indeed they do. He's also noted that in real legal systems, if you look around the world at real legal systems, they often do favor property rules. The standard practice in virtually all legal systems assumes the dominance of property rules over liability rules. So we thought this was really interesting grist for the mill. We decided to try and test it. So here's the hypothesis that we tested with respect to these rules. Property versus liability rules. Patent property rules, represented here by injunction, will, quote, promote the progress of useful arts, which we think of as a proxy of innovation, more than will patent liability rules, and in that case represented by damages. So injunctive relief will yield more innovation than damages. Now, the traditional claim is that you get fewer useful inventions, remember. The property claim is that without strong patent property protection, you'll get fewer useful innovations. So it's an additional variation of the original tragedy of the commons claim. So again, we did fully approved experiments, and we tested 4 different treatments in this case. We did a property treatment in which if infringement occurred and the owner of the legal entitlement, the patent, decided that they wanted to sue for infringement, they had a very, very high chance of winning in court. In some cases, 100% chance of winning. If they sued, they were going to win. They were going to get an injunction, and the injunction in some of our treatments was perfectly enforced. If you tried to make that patented invention again after you were enjoined against doing it, the system would simply say, you're enjoined. You can't make that, so you have to make something else. We also did a liability treatment where you would get damages. You'd get the value of the patented invention. You'd get that if you decided to sue. And again, in some of the versions, essentially if you sued, you would get the value back. But the infringer could continue to infringe as long as every time you sued, they paid the damages. We also had one treatment in which you got both injunctive relief and damages. So this was the great place to be if you were the owner of a patent. And this is the current patent system. You tend to get damages, and you often get injunctive relief. In fact, you used to always get injunctive relief, and now you mostly get injunctive relief. I'll speak about that in a second. And then we had another treatment where there was neither injunctive relief nor damages. So essentially, this is the commons again. So the human subjects, again, were paid. And every trial, there was a significant reward, a reward that we tried to calibrate to be effective in inducing the kind of behavior we wanted, which was absolutely rapacious use of the system to win at all costs. We did 48 trials, 5 players per trial, and each trial had a duration of 30 minutes. So remember, we had the injunction treatment, the damages treatment, both and neither. And remember that injunctive treatment is like a property rule. Damages is like a liability rule. Both is both rules. And then neither is neither. Just to remind you, innovation is the total number of unique inventions created. Productivity is the total number of inventions made in a period of time. And wealth is the per capita amount of wealth generated in a trial. Whoops. Plug that in. That's probably my fault. Sorry about that. Okay. And so here's what we got for innovation. Richard Epstein and the property folks would have predicted, I think, that the injunctive relief or the injunctive relief plus damages treatment would have generated more innovation than the other treatments. It turns out that between injunctions and damages, again, with the caveat that this is within our system, it may or may not reflect the real world, damages outperformed injunctive relief. And in fact, damages and injunctive relief outperformed the treatment where you got both. The winner, again, was the treatment that had neither, the commons, essentially. Now, what about productivity? Well, productivity, you get an exaggerated but similar trend. Injunctive relief plus damages the lowest. Injunctions a little bit higher. Damages quite a bit higher. And neither coming out on top. Wealth, per capita wealth, same sort of pattern. Damages outperforming injunctive relief and injunctive relief plus damages by quite a bit, and the neither treatment coming out on top. We sort of thought of the neither treatment as the control in this test, but you could think of it as the commons treatment in the previous experiments. So the results of this trial, these trials were sort of interesting. Innovation, productivity, and wealth, in this case, were highest without rules, without either rule, high with liability rules, low with property rules, and lowest with both rules. So from our system, and within our system, we conclude, based on the data, liability rules spur innovation, productivity, and wealth more than do property rules. Now, this is a challenge to the orthodoxy that property rules, or strong injunctive relief, a strong property conception of what a patent or intellectual property right should confer. This is a challenge to that orthodox view. But what's interesting is there have been a number of court decisions over the last 10 years which have seemed to march to a similar tune to our results. In particular, the eBay versus Merck exchange case. In the eBay versus Merck exchange case, the Supreme Court overturned a per se injunction rule that had pertained for a long time. In fact, the court below, the Court of Appeals for the Federal Circuit, stated in its opinion that if you get a finding of infringement, you get an injunction as a matter of right. That was the language that they used. So you get an injunction if you win. The Supreme Court said, no, you don't. In patent law, as with other areas of the law, you have to do a fairly nuanced analysis to see whether you deserve an injunction and to see whether society is harmed if you get an injunction. And so the Supreme Court said there's no as of right injunction. Sometimes you'll get an injunction and sometimes you won't, but you won't get it as of right. Now, empirical evidence since the eBay-Merck exchange case, which was in 2006, decided in 2006, indicates that now if you take those data as being reflective of the future, which they may not be, but if you take that data reflective of the future, the chances of getting an injunction are about 72% now if you prevail in trial and get a finding of liability. One of the more general findings that we think is interesting is that, according to what we found, the choice of legal rule does affect innovation, productivity, and wealth. And so Calabresi and Malamud's intuition that the choice of legal rule might affect outcome, it seems to satisfy, or our data seems to satisfy their intuitions. Again, possible explanations. Well, it could be that the patent game simulates poorly in general. We used bad parameters. We used bad choice of players. Maybe our sample sizes were too small. It could also be in the alternative that patent damages are better at spurring innovation and generating wealth and productivity. They're better than that, than what you would get under a system of strong injunctive relief. And again, that's consistent with the Supreme Court's change of the rule from an as of right rule for injunctions to a case-by-case basis where you have about a third chance of not getting an injunction and a two-thirds chance of getting it. Also, it could be that our results reflect the fact, maybe, that liability rules, such as damages, outperform property rules in patent law. And what's interesting about this is that there are many critics of the current intellectual property system that say that one of the problems is that we've created tragedies of the anti-commons. So in the patent context, there's too many patents blocking too much medical research. You need 1 million licenses to even do bench work. Now, there's some very good evidence that the story is more complicated than that, but that's a claim that's been made, for example, by Heller and Eisenberg, and that may chill medical research because of too many patents in the gene context. A recent case, the Myriad case, was probably influenced by a perception that gene patents were bad for medical research. That's the case that invalidated gene patents and said maybe you can't patent genes, a case that's going to be appealed, and a lot of people will be watching it. Another area that I think comports with this is the area of remix culture. The idea that people shouldn't be enjoined from taking existing intellectual property and fiddling with it, changing it, maybe even transforming it. If you needed to get a license before you did that every time, there may be very little remixing. But if you apply a liability rule instead of an injunction or a property rule to remix culture, then if you choose to remix, you would have to pay the economic damage that you inflict on the owner of the patent rights or the copyrights, but you wouldn't be prevented from doing the remix. You do it with your eyes open, and you'd pay for the damage that you did, but you'd be able to remix nevertheless. So one caveat about this second piece of research, as Calabresi and Malamud wrote, their work was meant to be only one of Monet's paintings of the cathedral at Rouen. To understand the cathedral, one must see all of them. And I think I agree with their statement, except that we're absolutely no Calabresi and Malamud. We know that. And we're not aiming for a Monet. Really, you could think of our research as more of a doodle compared to Calabresi and Malamud's work. And it's part of an ongoing project that we intend to continue to explore patents and innovation, and more broadly, intellectual property and the effects that it has on technological innovation. A couple of areas that we intend to continue looking into and modifying and hopefully improving are the theoretical framework that we're operating under. And we're always open to comments, suggestions for improvements about this. We're also constantly trying to refine our experimental design. We recoded the patent game entirely this summer to make it more robust. The parameters that we use, we're exploring a number of different parameters this coming year, and things like prosecution costs, how much time and money it costs to get a patent. We'd like to explore the effect that might have in our system. Enforcement costs, both in time, money, certainty, and expense. The patent term, we'd like to explore what happens when you vary the patent term. We'd like to explore the role of prior art. So how stingy or strict a prior art rule you have. Information costs. So for example, the secrecy question that was asked earlier, we'd like to try and explore what happens when you make it really hard to figure out what a good invention is and hard to figure out what other people are doing and see how that might affect performance in the system. Get at the trade secrets aspects. Numbers of players, the duration of the game. If you play the game for 30 minutes, it's highly likely that you're going to see different things than if you play it for 6 months or if you play it for 10 minutes a day for a year. So we would like to explore long-term ongoing games. We plan to put it on the web soon and let people essentially just play, come up with their own teams and play for long periods of time. We're really interested to see what behavior we might observe. Then damages. You know, we've already explored a little bit of damages and injunctions. One thing we'd like to explore with respect to injunctions is we'd like to see if you have a really strong chance of getting an injunction, the world before eBay versus Merck exchange, does that lead to different outcomes than if you have a very weak chance of getting injunctions, or let's say a 1/3 chance or a 50% chance, or the current prevailing chance, which seems to be about 72%. User characteristics, we'd love to look at different populations of people. The interpretation of our results, we would just like to say clearly that we have a system, an experimental system. We don't for a minute think that this is the final answer about reality, and in fact, we would say take it with a strong grain of salt. This is one simulation, one view of the cathedral, and maybe not even a good one. We hope that we've done as much as we can so far to make it realistic or meaningful, but obviously there's a lot of parameters that we could have chosen differently. There's a lot of different ways we could have built the simulation, so we recognize that. Future experiments, varying damages and injunctions, as I mentioned, and one thing we'd like to get at eventually, after we've explored a number of the above questions, can you come up with optimal sets of parameters where you maximize the amount of innovation, which ought to be the goal constitutionally if the Constitution's original founding fathers' motivation is to be followed? Are there ways that we can adapt the patent system to optimize or maximize the amount of innovation or productivity or wealth or some other important parameter? We think that that would be a fun thing to do and maybe even a socially meaningful thing to do, to see if we could feed into the policy system somehow and shed some light on how the patent system might be adapted to generate technological innovation rather than thwart it. And we're certainly not ready to say that it does one or the other, but in our system, we certainly have been given a little bit of pause about the received wisdom of patents and innovation, and so it certainly whet our palates to continue exploring this and to see if we can shed light into the policy realm and actually influence innovation. Yes?
You mentioned you thought about a couple of different ways of sort of getting at this issue of whether
That's a great question. What we would like to do ideally is we'd like to marry our experimental results to, this is more relaxing as a, we'd like to marry our experimental results with case studies from the real world, which is difficult because we now live in a world that is homogeneously patented. In the sense that if you want to be a member of the Maine Trading Club, the World Trade Organization, you have to join TRIPS, the trade-related aspects of intellectual property. And if you want to join TRIPS, you have to sign up to the standard orthodox rules of patents, trademarks, copyrights, and trade secrets that the Western world, that Europe and the United States have been living under for a long time. Now, that makes experiments hard. So we're reduced to natural experiments with countries, for example, that don't comply. So we might look at certain countries that often make it into the news for non-compliance, the ones that seem to frustrate the US trade representative. Even those countries are difficult to look at, though, because they're in flux. So India, for example, India for a long time was a target of criticism for low intellectual property rights. They appear to be in a transition to stronger, more vigorous enforcement of IP rights. Some people explain this based on the fact that they have a burgeoning local pharmaceutical industry and other technological industries. China is another country that comes in for criticism. And it's hard to know how to look at that data and what to use as the before and what to use as the after. But there are examples in history that we'd like to look at as well. So for example, Germany, Italy, and Switzerland at various times have or have not allowed patents for medicine, for drugs. So maybe by looking at some historical evidence, you might see whether there's an effective innovation, at least in that industry. So what we'd like to do is match up real-world examples like that, and we'll be forced to settle for historical examples and pre-TRIPS, post-TRIPS examples, because the countries that don't have patent systems often don't have a lot of technology anyway, and so it's hard, for example, to say, oh, Cuba, there's no patent system in Cuba, and there's little innovation, and so therefore we need a patent system.
It reminds me of some work I've heard about in the copyright space in Brazil with regard to music and how that plays out there. One other quick question, I don't know if others have questions, but I know that Academy of Sciences study, I think the conclusion was, it doesn't make sense to get rid of the patent system now that exists, but it's not really clear that it's providing a real advantage. Comments on that?
Yeah, absolutely. So that originally traces back, and unfortunately I'm blanking on the name of the gentleman, but it traces back to a gentleman who I think in 1952 or 53 said a similar thing. He said basically, and I'm not saying that he's correct, but he said basically, the patent system's a complete and utter disaster. If we were starting from scratch, we would never choose to have the patent system we have. But we already have it, and it would be a disaster to abandon it now because so many investment decisions are based on the existence of the patent decision that it would throw everything into disarray. So, yeah, I think that...
but the point of your work seems to be tuning the system, right? Even short of abolishing it, you've got some data to try and tune the system.
Yeah, I try. So my original background, I like to think, is as a scientist. And I'd like to think that I'm not wedded to the patent system or not having a patent system. At this point, I'm just so fascinated by how this system that we all depend on and we all assume works, that I want to keep exploring it. But I'd like to look into fine-tuning, if fine-tuning would improve it. I'd love to know whether no patent system versus a patent system would yield different results. And all sorts of other ancillary questions I'm really interested in. But we certainly don't take a position that the patent system should be abolished, and we don't take a position that we know how to improve it at this stage. I think we simply offer, one view of the cathedral, and we hope there's other views, and we hope that we're able to come up with other views ourselves. But we think it's an incredibly important question to study because so much depends on technological innovation. I think it's clear that the economy depends on technological innovation. The work of Solo and Samuelson, I think, has definitively indicated that technological innovation is good for economic growth. But we have this disconnect between intellectual property rights and innovation. And I think we need to explore that disconnect and figure out how to make it work properly, for individuals, for companies, and for society. Because if innovation's so good, we better figure out how to spur it. Yes?
I just have a comment. I'd be interested in seeing experiments where you vary the amount of time and money that it costs to come up with inventions to simulate, for example, the difference between the pharmaceutical industry and the computer industry, and also maybe the length of time that the inventions are good for. Again, in the computer industry where things just change so rapidly, you might introduce a new element like B prime and say that this now supersedes inventions that have element B, something like that.
Those are fantastic suggestions. Do you want to collaborate? No, those are great suggestions. One of the problems that we have is we built a system that's completely adaptable. So we can look into an infinite number of things. And when Bill and I sit down and try and figure out what to do next, it's really hard to decide. And then the actual carrying out of the experiments, it takes a long time to prepare. We need to raise the money. We need to find the subjects. We need to get the IRB approval, all that stuff. So we're constantly thinking, I hope we chose the right question to look at. But those are great suggestions. We'd love to look into those.
Yeah, and I'd be interested in your take generally on whether you think it makes sense to apply different rules to different industries.
I'd be happy to answer that question. I think clearly yes. I think from the perspective of the individual industries, it's hard for me to believe that software and biotech and the making of armchairs should all have exactly the same patent rights applied to them and the same patent terms applied to them. It's something that actually I'm working on in a different context. I think that it's clear from the research that I've seen that's come out in the last 10 years on that question, it's clear that different industries behave differently. And not to take that into account is probably a mistake from the perspective of generating innovation in those individual industries. One of the questions that sort of pushes back on that, though, is how complicated would it be to separate the industries? Would we have to have 10 different patent acts? Could we ever get that passed through Congress? It seems almost impossible to get any patent changes through Congress. We've been trying for 6 years to get some relatively modest changes made. But I agree that it doesn't make sense and it doesn't reflect the evidence that we already have to treat software the same as biotech, the same as automotive engineering. And it strikes me that we should be trying to optimize the effect of the patent system on innovation in every industry, because I think we want more innovation, and I think it's good for society to have it.
Where is that?
Oh, that's the North Shore of St. John in the U.S. Virgin Islands. I teach a class there every year, and that's just my favorite photograph ever, so I always end my talks with that.
Set going in, and then after they've played, they have learned a lesson, or they've reevaluated the best way to win?
Yeah, I do. And in fact, one of my colleagues suggested that the next time we do the trials, we should do a questionnaire afterwards and try and capture those attitudes. But I think that the players that play our game, I think they come out of it with a changed attitude towards patents and innovation, in the sense that I don't think it's clear to them that there is one winning strategy, and that having more of something, for example, stronger patents, actually spurs innovation. So yeah, I think that it does change their view. I'm not sure that it changes it in a consistent direction, but I think all of a sudden they think of the patent system as something complicated and organic and evolving and maybe hard to predict, which is probably good, because I'm a patent attorney and I certainly didn't expect these results in the game. I was pretty confident that I knew it was going to happen. I was going to be the supplier of the new footnote, and instead I got results that were quite different than what I expected. So I think it's a great idea. I think we'd like to do questionnaires afterwards. Thanks again for the opportunity to talk about this. I really appreciate it.